We're live.
Okay, great. All right, welcome everyone. This is Delegate Charlotte Crutchfield, and I am the chair of the Family and Judiciary Law Subcommittee for the Judiciary Committee. We're having our subcommittee meeting, which will start right now. And we will start by reviewing our first bill for this afternoon, which is HB 343. And that is a family law non-payment of child support sentencing bill sponsored by Delegate Henson. It's my understanding that this bill requires any sentence imposed due to an individual's willful failure to provide support for a minor child must be served concurrently with any other sentence against them for the same offense. So I want to just open it up to you, Delegate Henson. Do you have anything else you'd like to add to that, and any other testimony that you think is important for us to know about and hear about?
Thank you, Madam Chair. I'll only add to it that the bill was before the committee last session. I had an opportunity to speak with the vice chair of the committee about the bill and some concerns she expressed last session. I provided some additional information to the vice chair about ways that other states have approached this. I believe she was interested in having some options available. The options were not something that I wanted to introduce as amendments, but other states have taken a different look at making sure that that relief was there so that there wasn't over sentencing. My goal with the bill was to make sure that any sentences that were issued would be, as you stated, served concurrently, not consecutively, so that they didn't pile on. Ways that other states have approached it has been one of two methods. Either they have had additional factors that they have considered before they have allowed a judge to proceed to consecutive sentencing. So some states have preserved that ability, but you do have to have a two-factor analysis proving the barrier of you did willfully non-comply, and then there was some sort of extenuating circumstance, like you willfully non-complied and there was a high amount of arrears, or there was some other element that escalated the severity of that non-compliance, and then a judge could proceed forward after they made a showing of that to a concurrent sentencing. In some other states, they had that in very limited circumstances where it was only if it was a repeat offense could you escalate to the concurrent sentencing. So there was either extenuating circumstances, that was a number of variables, or only in very limited exceptions could you do that in other states. And when I looked at other states with that approach, there were only a handful of states that preserved the ability to do that. When I tried to find a parallel in Maryland law for something of that nature, Maryland Courts and Judicial Proceedings, Section 7504, when we're looking at the fine statute, just general fines and fees, it did have the ability to escalate the ways that fines are paid based on the severity as well. And that was the only parallel in Maryland law. But again, the way that the bill was drafted is my intention for the bill, but out of courtesy to the vice chair, I did find some additional support for alternate approaches to the same intention that's expressed in the bill.
Okay, thank you very much, Delegate Henson. And do any of the committee members have any comments or questions regarding the bill? Okay, Delegate Williams, I see you.
Yes. So Delegate Henson, I appreciate you doing the research about, because I did kind of have that in my notes. What are some of the other schemes that some of the other states are kind of looking at as around this issue? And I know you've kept the bill in the same posture, but I guess my question is, out of the various different schemes that you saw, do you have a preference at all? Or because, like, I mean, you know, the vice chair did bring up a concern, and we definitely don't want to over incarcerate people. And so I just was curious about that.
Thank you, Delegate Williams. Of the various ones that I saw, I did prefer the Tennessee approach, where they define what types of escalating factors would trigger the judge's ability to sentence concurrently. They had four features that would allow a judge to proceed forward with an enhanced penalty. If it was a repeat offense, if the lengthiness of the delinquency, and if it was done for personal benefit, if it was subjected others to great risk, and if there were no efforts to remedy. A person had to meet all 4 of those factors in order for a judge to proceed forward with the concurrent sentencing. And I felt like all 4 of those factors, 5. I felt like all 5 of those factors having to be met and present would really put us into that territory of something being egregious. And I felt like they really did run the board of kind of the variety of things that you see in these types of cases. And if someone met all 5 of those, I do think it would be appropriate for us to take a second look at what type of penalties were appropriate. I do feel like these child support cases, even when we're talking about sentencing for failure to pay, we have to remember the best interest of the child. The child is only a child for a maximum of 18 years. And even when we're sentencing a parent, we have to balance that with what the needs of the child are for the emotional support of parents and all those other things. And I did feel like that took those things into consideration as well.
Thank you.
Any other questions or comments? Would the committee be interested in an amendment of that kind to clarify? And to make sure the guidelines, there are specific guidelines and factors involved versus the way it is right now? Any thoughts on that?
I would say I like that approach. I think it does kind of help provide some additional clarity to the situation, but I'm open to hearing what other folks think about it.
Right. And Delegate Henson, you would be amenable to that?
Thank you, Madam Chair. I do prefer the bill as drafted, just striking out being able to go beyond 3 years for any individual person when they're sentenced and having them run concurrently, but in the alternate, that is the next, I guess the next best approach would be to have those factors that do take them into consideration, and having all 5 of those elements met, I would consider that the next best approach.
Okay. All right. And how does the committee feel about either approach? The bill straight the way it is or amending it? So I've heard from Delegate Williams. Anyone else have any thoughts on it? Okay. Otherwise, I think we just vote on the bill as is. Are we ready to vote on it? I don't see any other hands up. Let me see. I don't see anybody else with any other hands up. Okay. So is there a motion to move?
Malone's
the bill?
waving his hand, Madam Chair. I'm sorry.
Oh, sorry. Go ahead.
Malone, you're on mute.
Thank you very much, Delegate Williams. I didn't see him. I was trying to go through this quickly. Go ahead, Delegate Malone. Delegate Malone, I think there's something wrong with your audio. I know it looks like it's off, but we still can't hear you. Uh-oh, I think he disappeared altogether.
You hear me
Okay.
now? Somebody just let me in.
Yes.
Okay.
Yes.
A greater power. My question was there any opposition to this bill?
I believe the judiciary was opposed, just simply because it does remove some measure of their discretion.
Anybody
Delegate
else
Malone,
have any other?
I'm sorry.
Go
to
ahead,
interrupt.
Delegate Griffith.
Delegate Malone, I was
That was
looking at the only opposition was by the judiciary on this bill. To confirm that.
And
Thank you, Delegate Griffith.
once again, it was because of their discretion.
I believe so, Delegate Malone. If Delegate Griffith has access to the letter, is not present in front of me.
Yeah, I'm trying to get it in front of me now.
Yeah, and I don't have it either. Was it? Oh, okay. It was a Maryland Judiciary, conference.
Yeah.
Okay.
Discretion
It says
for the
Maryland-
discretion.
Yeah,
Yep, correct.
Yep.
Yeah, it's a 1-page letter from the judiciary.
Yep, it is. Mm-hmm.
I'm assuming the State Bar didn't weigh in at all.
No,
I didn't see anything. You only,
May I?
go ahead. Go ahead.
The Bar Association support, I have a letter that says that they support the bill.
Okay.
Family and Juvenile Law section.
Any other questions? Thank you.
Oh, yeah, great, thank you.
Any other questions? Let me see. Bear with me. I don't see any other hands raised. All right. Oh, Delegate Cox, there you are. Okay, go ahead.
I apologize, Madam Chair.
No, it's okay.
As to that judicial conference letter for the sponsor, was there a fix coming in for that? Or I think their primary concern was that they thought it was a extrajudicial activity that would probably not be appropriate for the separation of powers issue, I guess, involving them in policy.
Thank you, Delegate Cox. I believe that's speaking to the other bill that's before you all for consideration, HB 93.
Right, this one only talks about if this bill's enacted, the bill would limit the judge's discretion. Okay,
I apologize.
it's
What I get
okay.
for
This
coming in
is,
late.
yeah, so we're on HB 93, just for clarity. Okay, I'm sorry,
Well,
HB 343.
340,
HB
okay.
343. Yes. You got ahead of us a little bit. Okay. Any other questions? All right. Seeing
Madam Chair, if I can follow up to
none.
that.
Yeah, that's
So I
fine.
think-
Go ahead, Delegate Cox.
So I was also handed a similar judiciary letter on 343. Is there any, and it's opposition, is there any fix for that, I guess is the question.
No, the judiciary's letter on 343, their opposition was based on it removing some measure of their discretion. The judiciary would still be within their discretion to sentence up to 3 years. So they could still sentence for any measure that's lesser than that. And it would be well within their discretion to craft a sentence that was within the allowable time frame. So I believe that the fix for that is within the confines of up to 3 years.
Any other
And it doesn't-
questions?
So you don't, so Madam Chair, so you don't agree that it limits the judge's discretion? That's all I was saying here. Because
No, that's what it's,
Of
that's
what
what the,
again?
that's what the judge's opinions are. So that's up to us to just determine, is that something we want to consider, which we are doing right now. And also there's a letter from the state bar that is in
Right.
support of it.
On 343, I am not supportive
Yes.
of the bill. I'll admit, and my basis may be anecdotal, but I haven't seen
Okay.
judiciary abuse in providing sentencing, and unfortunately, I have seen people being abusive of their obligation to pay child support. And it's from my perspective, it's a policy call, and as a policy call, I can't support the bill.
Okay, anybody else want to comment on the bill? Okay. All right. Okay, then I say we move forward and we go ahead and we take a vote on the bill. Is there a motion?
I move the bill. Favorable.
Okay,
Second.
okay. And is there a second? Okay. All right, Delegate Shetty, Delegate Williams, and let's go ahead and take a vote, and let's do a roll call vote on this one, okay? All right, So going down the list, Delegate Bartlett,
This is on the bill, and I am in favor of the bill.
yes, this is on the bill. Yes. All right. Is Delegate Lopez here? Did not
Yes, I
see
am.
her. Okay. All right. And we're on the bill.
I'm a yes as well.
Favorable. Okay. All right. And Delegate Shetty.
Yes.
Okay. Delegate Watson.
Because it's Delegate Henson, yes.
Delegate Williams.
Yes.
Okay. Delegate Cox.
While I generally appreciate the concept trying to be accomplished, because of the objections of the judiciary, I'll vote no.
Okay. That's a no. Okay. And Delegate Griffith.
Yes.
Okay. And Delegate Malone.
Although, because it's Delegate Henson, I'm tempted to support it, but I'm a no.
Okay. Delegate Sham.
Yes.
Okay. And I am a yes. Okay. All right. 1, 2, 3, 4, 5, 6, 7, 8. 8 favorables and 2 unfavorables. Okay. All right, so that will move out of our committee. Next bill we'll go to is Delegate Henson's bill HB 3. And that bill authorizes the county to establish youth violence review committees to prevent violence and homicides involving juveniles through program services. It establishes procedures for local committees governing committee meetings, access to information and records, confidentiality and disclosure of information. And is there any discussion on that bill?
You said HB 3?
93, sorry,
93,
HB
all right.
93, yes. Let's see, do I see any hands up? Any discussion? Any questions? I also have present in the room with us the Department of Juvenile Services. And so Delegate Griffith, let's let them speak first and then I'll come back to you, okay? So is that Mr. Johnston from Juvenile Services? I'm not sure who's here with us. Yes.
Hey, I'm sorry.
Okay.
I'll actually throw this over to my
Juvenile-
colleague.
It's okay. So
Delegate Crutchfield.
yeah, if you will go ahead, if you'll go ahead on HB 93, because I believe there was an informational from you all or concerns.
Sure, I can just tell you, I think the main concern that we had, and we really appreciate Delegate Henson reached out to us a long time, it seems like a long time ago, back in the fall, and we had a chance to speak about the bill. And I know she looped in a lot of stakeholders, including state agencies and other potential partners. I think the concern that we expressed in the letter of information, we didn't oppose the bill, but we did suggest that we have a pretty robust process now that we have in place that we've been following. It's through our state advisory board. So that state advisory board is allowed now, after legislation was passed 2 years ago, to really do a similar process if that young person was on DJS supervision or in one of our facilities when something happened and they were either the perpetrator of a homicide or similar act, or they were the unfortunate victim of an untimely death. So we have a process in place there, and this body allowed us to increase the record sharing with our state advisory board to make sure that we would have access to the confidential records that normally wouldn't be able to be shared. So we do have that process in place now. So for those youth who are under DJS supervision and are, again, the victim of a homicide or, for example, a drug overdose or suicide, we would also typically look at those, or who are adjudicated delinquent for or convicted of causing the death of another. We have a pretty robust process in place. Delegate Grammer coincidentally is the one of the representatives on the State Advisory Board, who also is a member of that Fatality Review Subcommittee. So we do have that process in place. I think that was the main thing that we wish to convey.
Okay. And I apologize, Delegate Henson. I should have allowed you a few minutes prior to Mr. Johnston. Do you have a few words that you'd like to say or comments about the bill that you'd like for us to addition to what we know about it?
Thank you, Madam Chair. That was actually a great tee up from Mr. Johnson at DJS. I learned a lot from the process that they have in place for reviewing in custody deaths or incidents of serious bodily harm whenever a juvenile is a perpetrator there as well. It's because I learned so much from their process that there are amendments to the bill. I believe the amendments were sent over to the committee members. There's one amendment that's in one single document, and that single document has several amendments to it. It makes amendments to the education article, to courts and judicial proceedings. It makes amendments to the human services article, and amendments, those are the only articles. It makes amendments to those respective articles to allow the committee to do its work. And then there's another amendment that was sent separately that was the result of a conversation with the judiciary. The judiciary, to the point that Delegate Cox was making, the testimony he was reading earlier, felt that it would be not compatible with their ethical obligations to be a committee member. So as opposed to the judiciary being a regular member of the standing committee, they would be pulled out from that, and the work would be done in consultation with the judiciary when it's appropriate. So that amendment has been drafted, and I'm checking my email that's managed by staff just to make sure that that's been sent over to you as well. But with those amendments, I do believe that it would strengthen the work being done by the committee. I want to just reemphasize that this is enabling legislation. If our counties wanted to engage in this work, they would still have to then adopt these committees. It would be quite like the boards and commissions that happen at a city and a county level. What we have to do as the state is give them the ability to do this work in a confidential way that gets them beyond that initial barrier and gets them the ability to collaborate and get everybody at the table with this information. Thank you for your consideration.
And so Delegate Henson, would you do us a kind favor? I believe that I received the amendments and I sent them to the subcommittee. So the subcommittee should have them, I believe. But would you please have your office to resend them again, but not only to me, but also to the Judiciary Committee itself? Dylan should receive those as well. He is the Chief of Staff for the Judiciary Committee. So if you could do that. Did everybody receive those amendments? Did, wave or doesn't look like any, okay. Did you guys receive the amendments from that I sent out? Hopefully you did. Okay. But yeah, they need to receive those, Delegate Henson. And you said there were 2 amendments, right? I think I had, let me see, I have amendment 1, which was whatever you sent me, which, okay. So everything is in there. Okay. So let's do this. Let's go ahead and I will take some questions now from the subcommittee. Okay, go ahead, Delegate Griffith. I think you were first.
Thank you, Madam Chair. And it was just a comment. I just had a question about having judges on the committees. That's being amended out, so I'm satisfied. Thank you.
Okay, thank you, Delegate. Delegate Shetty.
Second. Thank you, Madam Chair. Thank you, Delegate Henson, for this bill. I think it seeks to do a lot of really important work. Just glancing through the testimony from that was submitted to the committee, and I note OPD's opposition, and I'm just curious if you have addressed any of their concerns through the amendments that you're suggesting.
Would you mind refreshing my memory what the nature of their opposition was?
Sure, I can pull it up. 1 second. They raise a couple of points. One is they're They believe that DJS already does some of this work through the state advisory board. Separately, they raise the, they raise, quote, real and significant conflicts of interest that are created by the bill. Specifically as it relates to, it says, in assembling a group who are tasked with both investigating violence and providing services, this bill creates an inherent conflict that are not resolved by stating the review will wait until the resolution of any, quote, criminal matters. And then their third concern raised relates to, it says that the bill doesn't require standardized collection of data. So I didn't know if you want to have an opportunity to share whether any of the amendments address any of these concerns.
Thank you. I appreciate that. With regard to the concern about it being similar to the DJS work, the work being done by DJS has a more limited scope. It's only to review those deaths or serious injuries that happen to juveniles that are in custody. And then one of the amendments, it changes the definition of youth to being anyone that's aged 24 years or younger. So DJS is looking at everyone in their purview, and we wanted to lift the cap to 24 years just as our understanding of what a youth is changes. So we do feel that the work going up to that age will give us the ability to get more of an emphasis on a group that's not being served by a lot of the analysis that's happening currently. And it really will be a unique study that's happening with the stakeholders. With regard to the conflicts of interest, there are two things in there that we really feel will root out any conflicts. One is the purposes clause and the scope of the work that's being done. When the stakeholders are at the table, they're at the table for a specific purpose. And the stakeholders that do investigative functions are not there in their investigative capacity. It wouldn't be dissimilar to other fatality reviews that happen. There are domestic violence fatality reviews. There are the work that's being done by DJS, and we don't feel that it would be dissimilar there. When we serve as legislators on different task force and in bodies, we are there. And we know how to serve in that capacity, but then also have our own professional capacities and be in places in dual spaces. So I don't think that that would be, I think that it's just a different way of viewing the task force. When it talks about standardized data collection, the leaders of this group are our police department and our state's attorneys. So these are groups that have a wealth of experience with collecting, storing, and keeping information. So I do think that because we put them at the helm of these task force, our nonprofits, our other groups are going to be valuable partners, but the ones that are the leaders of this task force are the ones that do have the ability and the experience with keeping information and knowing how to collect that information and how to keep it safe and confidential, and even how to share that information and explain it. Frankly, when you're talking about a homicide and you're looking at, records and you're reviewing records, we wanted to make sure we had someone that could interpret those records for the collective benefit of the group. And that's why when we had our nonprofits and our other groups at the table, I'll tell you that there was some push-pull on who should be the leader of the group. And we ultimately deferred to our police department and our state's attorneys because of their experience with dealing with this subject matter.
Okay. All right, Delegate Shetty, do you have any other questions? Can't hear her. All right, Delegate Malone, who is not there, okay? We'll go on to Delegate Watson. Oh,
I was here.
okay.
My question was for
Delegate
Mr. Johnson. And do you think this would be duplicitous, or do you think this might be helpful to your department's efforts?
Thanks very much for the question. Again, thank you for the opportunity to be here today. So to clear up one thing earlier, just so it's clear, it's not just, we don't review just young people in our facilities who may pass away. That's frequently, that's an incredibly infrequent occurrence, thankfully. But it's any young person who's under supervision. So that would include young people under state probation supervision or who've been released from a facility. I would say that I think for those young people who are under DJS supervision, I do think that this process would duplicate what we're doing already. I understand it has a slightly different lens to it. And certainly it has different people at the table, to Delegate Henson's point. but we are performing the review already. So I do think, from our end, we would see that as duplication.
Thank you.
All right. Okay, Delegate Watson.
Hey, Delegate Henson, thank you, Madam Chair. Delegate Henson, just a quick question. I thought I heard you mention something about the age of 24 and something changing in how we define youth. Can you repeat what you said?
Thank you. My cross-file on this bill is Senator Augustine, and he brought to this bill his experience in behavioral health and understanding how we define youth and how we're defining what makes up a young person. And the way that we've clarified that in the law with the age of 18 is a legal construct. It doesn't really, it's not defined by biology or anything that has anything to do with how we protect or care for or plan for a young person. And so when we set out to define in this bill how we should study and plan for and care for a young person and their safety over the course of their young life, we really wanted to be as inventive as we could be with the benefit of science and understanding what makes up a youth. And so as we looked at that scope, we raised the age to age 24. It was originally drafted in the bill, age 18, as it is in the law. But he brought his knowledge and skills to the table on that. And then so did our stakeholders that we collaborated with, that the better scope to look at was age 24, simply because of the way that the brain and the body matures. We realized that that was the better lens to cast so that we could get the most help to the people who needed it the most.
Okay, thank you. Delegate Bartlett, do you have a question?
I do have a question, but I have I'll make it really quick. What I hear from the bill, and when I review the bill, and what I see is that it's intended to be, among other things, but a preventive type of action and with a local lens. Am I reading, is that what the part of the intent is, to be a preventive measure? Because I saw the word in there, prevent. So is that part of the goal?
That's
something
correct.
that is outside? Yeah, okay. So preventive with in a local lens. So
That's
that it's done within the county, in particular to maybe the needs of the county. So it could empower the county.
That's correct.
Other thing is, the reason why I say preventive is because we're looking at youth who are not yet in the system, as well as youth who might possibly be in the system, right? With this?
That's correct. Yes.
Okay. So because I had to ask the same question after Mr. Johnston gave some very good and helpful information with respect to DJS. Then the question does become, how is there a duplication, or how is there an overlap? But what I'm hearing is a state advisory board with respect to DJS versus, or not even versus, but and also a local review. I'm not looking at the bill right now, but I don't know if you use the word board or committee, that would have a more distinct and targeted purpose, as opposed to this umbrella from the state advisory board. Is that right?
That's correct. Yes.
Okay. And one more thing, Delegate Henson, if I may, Madam Chair, I really like the fact that you're extending to 24, because we are hearing in judiciary on a regular basis about the brain development of youth. Excuse me. So I appreciate you doing that. Thank you very much.
Thank you, Delegate Bartlett.
Any other questions from the committee? What I'd like to do is to go ahead and table this discussion for now, and come back to this bill when we have additional time to do so with the remaining bills that we have to review. Again, DJS and Delegate Henson. But for right now, let's go ahead and we will adjourn for now. And again, I will send out some new dates and times for us to reconvene. Okay. All right. Thank you very much, subcommittee. Appreciate you guys. Just want to give you all a little bit of time. Our Judiciary Committee will start up at 1:45. Thank you. And again, appreciate all of the waiting delegates, Delegate Valentino Smith, Delegate Dumais, Delegate Henson for being here. And again, we will send out new dates when the committee reconvenes. Thanks again, appreciate it. Bye.